Hi, everyone. Welcome back to VA Made Easy. I'm VA accredited attorney and U.S. Army combat veteran Ed Farmer. So last week we did a reaction video for Combat Craig, analyzing the advice he gave to certain veterans. This week we're going to do a reaction video for VA Claims Insiders. Now, I think it's obvious what my views are on the VA Claims Insiders in regards to how they charge veterans. I believe they violate certain statutory and regulatory laws in the way they charge. But again, this video is not about that. This video is critiquing the advice they are giving to veterans. If you guys are looking for representation on your VA disability claim, I am VA accredited. I charge according to the rules, which means I don't get paid unless you get paid. If you're looking for help, visit me at vetlawoffice.com. But for now, let's get into the VA Claims Insider video. So this video is entitled, What are VA Presumptive Conditions?
Okay, so what are VA presumptive conditions? Bottom line up front, presumptive conditions are conditions the VA automatically assumes were caused by your military service as long as you have qualifying service.
So I really disagree with that. Nothing is automatic with the VA. My definition of a VA presumptive condition is a condition where you no longer have to prove that that condition is related to your service. However, it's not automatic. The VA can actually rebut that presumption. Well, let's see what else he has to say.
Now, before I explain what this is in more detail, I first have to explain what's called service connection. Service connection is a requirement of every VA claim, and unfortunately, it's often the hardest part of the VA claims process for many veterans. And there are three parts to it. These three parts are laid out in what's called the Calusa Triangle. Calusa was a court case that established the evidence requirements for service connection, and the triangle just refers to the three parts, of course. So part number one, to be able to get service connection for your disability, you have to have a current medical diagnosis of your condition. Now, current means that you have to have the condition in present day. If you were diagnosed with the condition in the past and recovered from it, you likely aren't eligible for VA disability for that condition any longer.
So he says, well, if you had a condition in the past and you no longer have it, you probably don't qualify for disability at this time. That is true. However, let's take an example for prostate cancer. Maybe you had prostate cancer in the past, no longer have the prostate cancer. However, do you have any residual effects from it? And that's something that you have to consider as well. Maybe the primary condition has resolved, but if you have some residual effects from it, you can get service connected for those residuals.
Number two, you need evidence of an in-service event, injury, disease, or aggravation. Now, this is the thing that you claim caused your disability, and it's something that happened during and because of your military service. And you have to have evidence of this. And that can come in the form of your military records or lay statements from people who were there and statement from yourself.
So he's talking about the in-service event, injury, or disease. This is a criticism I had of Combat Craig. I said he didn't necessarily tell people that you have to have an in-service event, injury, or disease. I think they actually do a decent job here of saying you have to prove that, and you could prove it through service records, or you could prove it through buddy statements. Buddy statements are extremely important, guys. As I've said many times before, those could make or break your claim.
And number three, you need a nexus or a link between the first point and the second point. So basically, this means that the current medical opinion, the current medical consensus around your disability has to agree that what you're claiming caused your condition actually caused it. It has to be provable by the medical evidence. And usually this comes in the form of like a probability statement from a qualified medical professional.
So when it comes to the medical nexus opinions, the standard of proof is 50-50 or as likely as not. So if the evidence against your claim is equal to the evidence for your claim, the VA is supposed to find in the veteran's favor. In reality, that doesn't always happen, but that is the rule. So if you have a positive medical nexus opinion and they have a negative medical nexus opinion, all else being equal, the VA is supposed to find in your favor.
So when it comes to presumptive conditions, you don't have to satisfy the evidence requirement for the second part of the Calusa Triangle, the bit about evidence of an in-service event, injury, disease, or aggravation. If you have a condition that's on a VA presumptive condition list, they automatically assume that something happened during your service that caused it.
What he's saying here is that the presumption eliminates that second element of service connection where you have to prove an in-service event, disease, or injury. Yes, that is true for a part of the presumption. So, for example, the PACT Act creates a presumption that you would have been exposed to burn pits, particulate matter, basically toxins, if you could show you're stationed in a certain country at a certain time. So again, it's not automatic. There are certain elements you have to meet. And so the presumption does help you meet that second requirement. Another thing the presumption does that I haven't heard him talk about yet is that it helps eliminate that third requirement, which is the medical nexus opinion. And what the presumption does in that case is presume if you have a certain condition that it will be related to your service if certain conditions are met.
For example, Vietnam vets can be eligible for a list of conditions that are associated with Agent Orange exposure. So if you were in Vietnam and you were exposed to Agent Orange and you were diagnosed with a condition that's on the Agent Orange presumptive list, then you don't have to prove number 2 of the Kaluza triangle. You just have to show a current diagnosis and you have to show that you have qualifying service.
He's mixing up. There's actually 2 presumptions that is created for Vietnam veterans. First, there's a presumption that you're exposed to Agent Orange if you were boots and ground in Vietnam or in the water off the coast of Vietnam. So that's one presumption. The other presumption is the one that eliminates that need for a medical nexus opinion. So if you have one of the presumptive conditions of Agent Orange, if you have that diagnosis, the VA will presume it's related to your exposure of Agent Orange. I think he could do a better job of explaining that presumption, that it actually is 2 presumptions that takes care of not only the second element of service connection, but that third element of service connection.
There were also many conditions recently added to the presumptive list by the VA PACT Act, and these have to do with exposure to burn pits, as well as Gulf War presumptive conditions. So if you have something like chronic fatigue syndrome, fibromyalgia, IBS, and you have qualifying service, then you could be eligible for a VA rating for one of these presumptive conditions.
That's correct. Those are part of the Gulf War presumptives.
Frequently asked question number 1, can the VA deny a presumptive disability? Yes, the VA can deny a presumptive disability claim. If there is no clear evidence that you have a current diagnosis and you can't prove that you have qualifying service, then they absolutely have the right to deny your claim.
So not only can the VA deny you if you don't have the correct diagnosis or service, the VA could also rebut your presumption. Respiratory cancer is one of the presumptive conditions under the PACT Act. So let's say you had lung cancer and you're claiming it as a result of burn pits over in Iraq. Well, even though you have a presumptive condition and you meet the presumptive service, the VA could still deny that if they're able to provide medical evidence that rebuts the presumption. So, for example, if you smoked a pack a day for 20 years, the doctor could say, I don't think that his lung cancer is from his time in Iraq. I think it's more likely that it's from him smoking a pack a day for 20 years. The VA could use that medical evidence to rebut the presumption and deny your claim.
If you filed a claim in the past and were denied, and the condition that you were denied for is now on a presumptive list, it might be a little bit easier to get that VA claim approved, but you need to file what's called a supplemental claim. How do you file a presumptive VA claim? Well, it's similar to how you file any other claim. There are 3 methods.
Yes, if you've been denied a condition in the past, the correct procedure would be filing a supplemental claim. VA Form 20-0995. You need new and relevant evidence. New meaning it's never been considered before. Relevant meaning it goes to proving your claim. So that was a VA Claims Insider video. Not as bad as I was expecting. I've never seen one before. I think the information was a little basic. I don't think they did a very good job of explaining presumptions, but overall the information was okay. All right, guys, that does it. Again, if you need representation, visit me at vetlawoffice.com. There's no fee unless I win. Until next time, keep liking, keep subscribing, and as always, you have the power to change your VA claim.